Ladies and gentlemen, we have an outstanding program this evening. We're going to be talking about an update on the Melissa Calusinski case. And to talk about this case is to my left is Dr. Thomas A. Rudd, former Lake County coroner, and he's been referred to by his attorney as a stellar forensic pathologist. He's a licensed physical physician and surgeon, board certified in anatomic and clinical pathology. Been in Lake County since 1979.
Yeah, I started practice.
And also to his immediate left is attorney Matthew Stanton, who is an attorney at law. Greetings, folks.
Thank you.
Good evening.
We're very happy that you've taken time to give us an update on Melissa Calusinski case, which required a lot of attention here in Lake County. But first of all, before we do that, we want to have Dr. Rudd tell our listening audience a little bit about Dr. Rudd, your personal and professional background. Well, I know we could do a whole program on it, but just give us a little bit.
Well, let's just say that this is the first time I've appeared on television since not only leaving office on December 1st, 2016, but 2 months following that, 2.5 months following that, in February of 2017, the state's attorney of this county decided to indict me on election code error, a clerical error. And what the state's attorney did was took an election code mistake and criminalized it and indicted me on 5 counts of alleged, what would it be, perjury. And he decided to try to get me convicted of that, which would have been a felony, and then I could have served jail time, but more importantly, I would have lost my license. But his real goal was that once they've gotten me out of office, they were still scared of me. They were fearful that I would come back 4 years later and win. So they needed me out of the picture for at least a minimum of 7 years. And so as we got involved in the case, and it was a comedy of errors, I'll just give you a few examples. The first special prosecutor they got, because the state's attorney couldn't prosecute me because the allegations occurred while I was in office, and therefore the state's attorney represents me, so he can't represent me and go after me. And so he had to send it to, I believe, an appellate court in Elgin. The first prosecutor they gave me was a former LaSalle County prosecutor who lost his election, and he was indicted just before we were going to trial. He was indicted on 17 counts of stealing money. He formed a vigilante police force in LaSalle County. He collected $500,000, and he was tossing it out to various communities. In essence, it was campaign money. He had people arrested for alleged drug crimes, collected money from them, and then used it in his community. So that was the first person they picked. The second person they picked, sadly, developed a serious illness. They got a third guy to prosecute me. We went to them and said, we know what you want. You don't want Dr. Rudd to run again because he's honest. So let's take this out of criminal court and put it back in the electoral rules. And I plea bargained to a misdemeanor to election code violation. Therefore, I did not commit perjury. Therefore, I was not a felon.
So Dr. Rudd, are you saying that you were charged, and this was taking place in criminal court, but the part of the plea bargain involved you pleading to election code?
That's correct, the election code violation. So therefore, as my attorney told me, it's not perjury, nor is it a felony. Okay, but they got what they wanted, the Republicans. They didn't want me to run for 7 years.
But what I think is interesting, and I don't want to butt in, interrupt
Please.
it with
No,
your story,
keep
was
going.
that you were not charged under the election code
That's correct.
initially. I mean, when these types of clerical errors have happened, the things that have happened in other campaigns, which have happened frequently, they're challenged at the electoral board level, according to Illinois law and the Illinois Constitution. And the circuit court is a court of review. So it's not a court of original jurisdiction. So I was all along surprised that you were not challenged in front of the election board in Lake County, that it was waited until the election was over. And then after the election was over, we find this complaint against you styled as a criminal charge of perjury. Perjury. I mean, what did you have to gain?
Exactly.
How could you have, did you form an intent to deceit and to gain? I mean, that's classic criminal law. So it surprised me all along that it was in the venue of criminal court. That's where they cornered you.
Let's pursue this a little further. Let's just remind the audience what happened. When the Republican Party went after me and pointed out the 5 sheets that I signed that I did not circulate, which I did not know was wrong, what did I do? Did I fight it? Did I try to make an excuse? No. I did the honorable thing. I said, I made this mistake. The law says I can't do it. I withdrew my candidacy as a Democrat for the coroner's office. I said I'll run as an independent. And instead of needing 800 or 900 signatures, I needed 10,150.
It's a part of the law that needs to change, but it makes it very difficult for anybody from outside the 2 major parties.
In other words, had you not run as an independent, you'd have been okay.
No, had I run as well, what I was trying to do is that I was told I made a mistake, so the honorable thing would be to withdraw.
Okay.
Okay. Now, had I fought it, the electoral board could say what you did is error and throw me off the ballot. I did not want that to happen. I did not want a decision where I couldn't run at all.
Okay.
So I said, look, I'll withdraw as the Democrat and I'll run as an independent. Needing 10,000 signatures, the community rose up in support, tremendous support from the community. We got almost 15,000 signatures. What did the Republican clerk of Lake County do? She ruled against me, saying, well, Dr. Rudd, despite the fact that you withdrew as a Democrat and the fact that you didn't vote in the primary, you're still a Democrat. Like Hotel California song.
So which was a separate decision than the ultimate perjury charge. It was just another questionable decision that kept you off the ballot.
Correct. And so we went to circuit court, and prior to the circuit court hearing, like the day before, a similar candidate in the state of Illinois did what I did, and the judge in Effingham County put that person on the ballot. See, we showed it to our judge here in Lake County. She said, too bad, you're off. So we went to the appellate court. 2-3 weeks before the appellate court hearing of mine, a United States federal court in Bloomington, Illinois, took that law and that segment that they threw me off,
The Illinois law.
the Illinois law,
Okay.
and said it's illegal and unconstitutional. Put this person on the ballot. But these 2 counties have borders, so therefore they didn't encompass me. So the appellate court judge put this person on. Our appellate court said, sorry, Dr. Rudd, you're off the ballot.
There's several appellate districts within Illinois, so there was what we would say a split between those districts with different decisions. And so because Dr. Rudd is here in Lake County, the decision he's talking about that you would think would have set a precedent was in a different district. So
You said that was a similar situations in other states, right?
Well, let me make one more important statement. I want the public to hear this. The Republican Party tried to make me sound like some evil, nasty politician from Cook County, a total corrupt individual. And I just want to remind the public that there are 18 states in the United States that allow what I did, including the state of Florida.
Okay.
So you can send your circulators out. They gather the signatures, they give them to you, and you can sign for them. So it is not like the law of not committing murder, which is illegal everywhere. Okay, not only the states.
Well, it's not it's not really an immoral act.
Correct.
Like the criminal law is based on morality, and then we have laws that are just regulatory. That's because people decide to do them this way, like say speeding or something like that. It's
One more comment before we go to the Calusinski case. There is a candidate who ran for assessor in Cook County named Rala, R-A-I-L-A. She did exactly what I did. The election board threw her off the ballot. 2 courts put her back on the ballot. Now, why would 2 courts put somebody on the ballot if what they did was so criminal? Why would a judge put somebody back on the ballot if that was a criminal act? So this whole thing was phonied up by the Republicans to get me off the ballot and not run.
I'd like to interject a point too, because it's really underscores the fact that the election laws in Illinois are so arcane, they're so old-fashioned, they're so specialized that they set up problems like this. So here you have Dr. Rudd, who's been an elected official. He's won awards, statewide awards for public service and law enforcement, and, in his position as coroner. Immensely popular, gathered the 15,000 signatures, as you said, in short time. And none of that public choice gets through to be heard because we've got these rules in Illinois that you have to get so many signatures and you have to do them in a certain way with certain oversights within time. And as Dr. Rudd pointed out, if you were a major party candidate, countywide office, between 800 and 1,000 signatures. If you're an independent, that would be required. You have to get 10,000. Now, that's weighing the balance. What is the purpose of these laws? I think the only purpose can be that these are laws to keep serious candidates, to make sure we have serious candidates, to keep interlopers or people that are just, throwing their name on the ballot. In other states do this in other ways. By having our very complicated, difficult to comprehend rules about getting your name on the ballot means that you have a lot of specialists, whether it's election lawyers or professional hacks or whoever that works in politics that know how to play. It leaves it up to specialists, and there's good people that get tripped off because of the signature gathering and the protocols to get on the ballot that should be opened up and should be made easier, and we should learn from other states about that.
Well, we have to do, I've been doing some research on Dr. Rudd, and my findings are that you're honest, to follow up on what Attorney Stan was saying, honest, professional, compassion, complete integrity, right? And you speak the truth. You say, well, but you state that you would not be threatened, by politicians. Of course, you realize that truth has power, and you're required to take a stand, and you have taken a stand.
Right. The truth is hard. The truth is
And
not
he's
easy.
paid the price for it.
That's right.
Yeah, that's the key.
As often is the
Right.
case, as prophets and truth tellers throughout history.
Right. And one of the reasons I was so despised by certain individuals in this county.
And you admitted the mistakes on the technicalities of the law, and you withdrew. So,
Right. And the honorable thing was to step down. Most politicians would go in front with a bevy of lawyers, powerful lawyers, and argue the case. Okay. And I thought, do I want to get on the ballot by doing something wrong? They'll only use it in the election. Okay. So no, I'll step down. And I thought, heck, if I get the signatures, I'm on the ballot, I'll win. But no, they couldn't afford that. They hired some high-power attorney to fight it. okay? In fact, listen to this. They challenged 5 of my sheets based on I signing what I didn't circulate, and they also said some of the signatures were bad, and they even paid somebody to sign signatures of dead people, okay? And so when I got my 15,000 signatures, did they challenge one of those 15,000 signatures? No, they challenged not one, because they knew they were all good, okay? If they wanted to knock me off, why did they need to spend six-figure lawyer to knock me off on a technicality when they could have gotten the signatures that allegedly the signatures I
Now,
get are
Tom,
so bad?
are you speaking about the lawyer that later came to your aid?
Yes, he was so incensed.
This is very interesting.
Yes, the lawyer they hired, he got me off the ballot on a technicality, and then, like most lawyers, you can hire them to help you do something, and he followed the rules.
Okay.
And got me knocked off on a technicality. But when he saw that I was indicted, he was so incensed at what they did, he joined my team in defense.
But when you say what they did, meaning what we were referring to earlier was to bring an election code violations as criminal charges.
Correct.
Which so offended the ethics and the sensibilities of this attorney that he came over to Tom's side.
Right. Right, and he worked with us for a brief time, and even presented in front of the judge once. What did the opposition, what did the Republican Party do? They, on a technicality, said, you can't use him anymore because we used him, and there's not enough time between the cases, so there's client-attorney privilege, so you can't use him anymore.
So they were doing all of this to ensure that you will not be in office again.
Correct.
Giving you enough time.
Right.
It will be after the next election.
Well, it'll be 7 years. let me tell you what I can't do. I can't run for office, state, county, or municipal.
This is part of the deal that you took from them.
Nor can I be employed for state, county, or municipal. If I can't even apply for a job in the state, the county, or municipal government.
For
7 years.
7 years.
Right.
So, Dr. Brooks, you could become elected coroner,
Yes.
but you couldn't hire
You couldn't hire me.
Tom.
Okay.
So,
So-
and if that doesn't prove that this was a political prosecution,
Exactly.
what does?
Correct.
I mean, here's the penalty, is threatening you with prison, a felony, and all these other consequences, and what that would do to your future and your family and everything else. But accepting a plea bargain where you say, okay, I'll agree not to run for office.
Okay.
Doesn't that even take something away? I would think that the people of Lake County should have to weigh in on approving that.
Yeah, you would think so.
There's a lot of community support that you got, and you stated that.
Tremendous.
Community was aware of what was going on and so forth.
They came out of the woodwork and busted their buns. Remember, a regular elected official needs about 800 to 1,000 signatures, as Matt said, in the county. He has 90 days to do it. Okay. I had to get 10,000 signatures in 90 days. They didn't give me any extra time, okay? And so we got 14,650. And so stunned them, they didn't even bother challenging the signatures because they would have had to knock off 500. Okay, so instead they hired this very good attorney who found some quirk in the law that the clerk of Lake County agreed with. Okay, she could have said no, but she agreed. Okay, and it's totally ridiculous. Okay, it's just totally ridiculous.
Let me pick up on Dr. Brooks' point. You said that there was a lot of community support for Dr. Rudd. And this leads to another thing about this prosecution that I think harms us all. There was a lot of public support, but there was not a lot of elected officials, party people coming up and forward from Tom's circles to make a stand. from advertising.
Right, and as Matt clearly said before, a few minutes before, these laws are developed this way to go after people. In California, I believe it's California, I could be wrong, in another state, all you do is apply to run. You don't need signatures.
Sometimes there might be a fee.
That's
you know,
correct.
something like that.
Right.
That takes the place of all this signature gathering.
Correct, exactly.
And you know, most of the signature gathering, I don't want to talk too much about this, but
I think it's good.
it's being done by professionals anyway.
Right.
It's very rare where you have, you know, your neighbors that are going to go out and do the hard work of knocking on doors and interrupting people to ask them for their signature, which gets harder and harder to do. It's typically people that they do that for candidates all over the place. They come out as signature shock troops.
Right.
So it's not even a grassroots political thing. It's just this sort of niche professional
Right,
job.
a lot, right, and expand it further. A lot of them get jobs from the candidate. So the person's gathering these signatures, the way they're paid back is with a political job.
Okay.
All right? So how fair is that? All right? So I think what Matt said is good. If you need 800 signatures, wouldn't it be better to pay $800 so that we could reduce the debt that we have in our government? $800 versus 800 signatures?
Meaning like a registration fee.
Correct.
Yeah.
That's correct.
Wow. Wow. Okay.
Well, let's get back to
Okay,
one of the...
we're talking about Lake County cases that require wide attention. And we've been talking about the Dr. Rudd, and I gave you the findings on him: an honest, professional, compassion, complete integrity. You know, and what does it take to run for a coroner too? Is it?
Unfortunately, it requires minimal requirements. Right now, it is basically a high school degree
Okay.
and no felony convictions.
Okay.
So you can see why they went after me.
Okay.
Okay, and unfortunately, here's another sad fact, and it's occurring right now. You can be elected into this office that pays $125,000, and you can still practice dentistry at the same time.
Wow.
So the current coroner is still practicing dentistry, and he's earning $125,000 as the coroner. So he's two-timing the people.
No, that's not the case with other county offices, though. I mean, like state's attorney, you give up your practice.
Are you sure about that?
Yeah,
'Cause
you can still be an owner of an office, but you
right.
can't be practicing. And it is one of the only offices where it is required that you're a licensed attorney.
Right. Okay.
But I think even the sheriff.
I'm not sure. I know that the current coroner is practicing full-time and also earning $125,000 as a coroner.
Do you take a pay cut after you?
Well, you know, most dentists pull in about 200, and he's making an extra 125, so he's pocketing 325, working 2 days a week.
Wow. Well, let's give Matt a chance to talk about the Melissa Calusinski case. Like I mentioned, required a lot of attention here in.
Well, let
Lake
me
County.
let me do
You ready?
let me do a preview.
Yeah, I think so
preview.
because I have not been directly involved in the case
Let
at
me-
all.
yeah, well,
I
we
have been an observer of the case, and I am an attorney and I'm a professor of law, and so I follow it. And
Okay, Dr.
let me-
Rudd,
let me do-
you still have the floor.
Let me do an intro, because what we need Matt to comment is the actual laws that are applied here.
Okay.
So basically what happened was this. So I'll give you a little summary. We've got time. I came into office in December 12, and the first thing I did was in 6 weeks analyze the Hannah case, labeled it a homicide, despite the fact that people didn't want to do that because they were trying to cover up a murder.
the Hannah case briefly.
The Hannah case was a young man who was batoned to death by 6 North Chicago cops because he was having a fight with his girlfriend. But anyway, the powers to be, the state's attorney, the coroner, labeled it an undecided manner of death when in effect it was a homicide. Anyway, after doing that, I was asked to look at the Melissa Calusinski case, and I don't want to mention the decedent. I don't want to hurt the family or anything, so we're going to leave the decedent's name out. A 16-month-old child who allegedly died at the hands of Melissa.
It's a tragedy.
In Lincolnshire, Illinois. And upon reviewing the autopsy, it was totally botched, totally the opposite findings of what was said. And so I had Dr. Nancy Jones, the former medical examiner of Cook County, who was working for me. I had her review the case. She agreed with me. We published brand new findings, and we sent the findings to the state's attorney saying, look, there's a drastic error here. She could not have possibly killed this child.
This was after she had been convicted.
Correct, in 2011. She was convicted in 11. I reviewed the case. Despite that, the state's attorney refused to meet with me.
Did the state's attorney have any kind of review board at that?
Oh, that's a good point. When the state, let me back up. The state's attorney, when he won the election in 2012, ran on the basis of saying we're going to stop these wrongful convictions. I'm going to establish a review board. So he gets in, he establishes a review board. He reviews almost every case except the Calusinski case.
Oh.
He refused to review it.
That was never part of that.
Right. He said he read the case and he read the medical evidence and he doesn't need to do it. I don't know of a state's attorney that can understand medical science other than having an MD. But the current state's attorney thinks he's a doctor. And he said, I've read the medical evidence and she doesn't deserve a trial. He doesn't know the medical evidence. I challenge him to come here in front of you. We'll debate the medical evidence. Okay? He won't do it. He won't do it. Okay? In fact, when I sent it to him and sent him a letter saying, let's meet and talk about it, when an attorney went to his office to find out about it, he was told by the state's attorney, I never received it and I never read it. So this reporter comes back and I said, okay, here's the letter. I Xeroxed it, I gave it to him. He went back to the state's attorney, caught him in his lie, and what's the state's attorney say? Well, I didn't get it. My second in command got it. I didn't read it. He read it to me. So he was technically correct. He was parsing his words. I didn't get it. My second in command got it. I didn't read it. My second in command read it to me. That's the type of state's attorney we have. Okay? So anyway, we go through this long process within the county. Oh, let me back up. So what is Melissa's case? How does she fight it? Well, she has to go through 3 levels of courts. The very first court she was convicted on, the appellate court, and then the appellate court, and then Supreme Court. On the original evidence, despite the fact they now have new evidence showing it could not happen, they were in the middle of the process of doing the analysis and asking for a new trial on the original evidence. So they had to spend a year or two, whatever it was. Then they take the new evidence and they go back to the appellate court, and then they go, the court here, and then the appellate court, and then ultimately the Supreme Court again. So they have all these ways of doing this and taking time. Okay, so when they got the new evidence, they went to the same judge, Shanes, and he dragged it out a whole year and had her suffer in jail before he would make a decision. And that was September 30th, 2015. And in that decision, he spent 4 or 5 pages attacking me for being a media darling because this case was on 48 hours. I never heard a judge attack the coroner for trying to get the right results. So it ultimately went to the appellate court in April of this year. They spent 2 months.
So you're talking about when you said you were attacked, you're talking about the attempt to get a new trial based on new evidence.
Correct. We're in the second stage.
Got it.
Right.
Okay.
And so it went to the appellate court in April. It looked really good in the presentation. And 2 months later, in June of this year, the appellate court turned her down. which, all of us were like,
Now, for listeners too, an appeal is not a whole new trial. It's not looking at all the stuff over again. It's looking at discrete issues that are appealed, and the appellate court bases their opinions, supposed to base it on the record and the argumentation. So in this instance, Calusinski was trying to get a new trial based on claiming that there was exculpatory evidence that was withheld. Exculpatory meaning evidence that the state and the prosecutors had that could have helped her in her defense, perhaps exonerating her.
Let me explain what the evidence was. A phone call came to Melissa's father saying that there were other x-rays in the coroner's office that will show that there were no skull fracture. So he calls me up. I go to the file of the decedent, and there's no x-rays in there. In fact, that was the first time I knew there were x-rays. Okay? So I asked the deputy coroner in charge of the x-ray machine and the files, see what's on this case. He brings back 3 films, 3 x-rays, okay? 2 of which are clear, very good x-rays. Not the best, but not bad. And clearly shows there's no skull fracture. Well, lo and behold, we find out that Melissa's first attorney had x-rays that were totally uninterpretable. Now,
Tom, I just want to stall you. Can you mention real briefly why a skull fracture makes a difference here?
Okay, well, if an x-ray doesn't show a skull fracture, then what you see with your naked eye as a skull fracture doesn't make sense as a physician.
But the fact that if there was a skull fracture would have been consistent with Melissa's initial confession that was repudiated.
Right.
So if there is no skull fracture, then there is no way that Melissa could have committed this crime.
Right.
So that's why.
And this is where the botched X-rays come in. The botched autopsy. The physician, a pathologist who did the autopsy, he was shown the films, and he said there's no X-ray. There's no skull fracture. So he should be alerted that what he sees with his naked eye and what he sees with the X-ray doesn't match. He should have taken tissue that he saw with his naked eye and put it under the microscope. That would confirm it. That's what you're supposed to do. He ignored it. Not only did he ignore it, he got rid of the tissue, so we couldn't go back to prove it. All right? So anyway, we're now fighting this in court, or they are fighting it in court, and they're trying to show that these x-rays weren't available to the first attorney. But listen to how he worked this out. He was given a disc with these bad-looking films, all right? What he didn't know
They were computerized.
They were computerized. What he didn't know is that they were condensed or compressed, but just sake of ease so the public understands. So you had to uncompress them. Well, he didn't know that. So he went back to the prosecutorial attorney at the time, Kristen Bishop, and said, I can't read these. So she went back and told another attorney, DiMartini, the defense can't read these x-rays, see what you can do. He allegedly goes and checks and he says they're no good. This is all we have. So he asks a second time. So they go back and then they lie. They claim they talked to the same deputy coroner who brought up the good films. Remember, in 2011, and the guy I used was able to bring up the good films. They claim they went to him and asked him to make better images. He claims under oath, they never talked to me. All right? So now we find out that the judges ruled that despite the fact that the prosecution in this case says there aren't any better films, this appellate court said, I'm sorry, just because the prosecution says that they don't have any better films, you are still mandated to try to figure out how to get good x-rays. So in other words, they're saying, well, we gave you the ability to uncompress, so it was up to you to find out how to do it. even though the prosecution said, well, we tried it and we can't do it. Okay. What sense does that make?
Also, Dr. Rudd, you should mention that in the state that those x-rays were given to Mr. DeLuca, the defense attorney, they were unreadable. They were just
correct,
black or very dark.
Because they were compressed.
So they were, yeah.
Okay? So this makes absolutely no sense. Now, we have another situation where this so-called pathologist who was on staff at the time, he did not do the autopsy, Dr. Montez, but he was called in to assist Dr. Choi in preparation for the court. Mm-hmm. He comes in and he claims under testimony that he handled the autopsy body. He moved the skull, he did this, he did that. Well, when we talked to the chief deputy coroner at the time, he gave testimony that Dr. Montez never touched that body. What he did was he sat in the front office and looked at Dr. Choi's photographs from the day before. Okay, the autopsy was done on day 1. On day 2, they brought Dr. Montez in to confirm what Choi saw. He never handled the tissue. He just looked at Dr. Choi's pictures. So he committed true perjury. And yet, the court said, no, that's not the case. We found this policeman who said the body was out there and it was available for viewing, but he doesn't say that Dr. Montez was there viewing it, okay? Because when they re-examined the child on the second day.
So Montez said that he saw it himself.
That he handled the body.
He handled it, and there's another witness that said no, he didn't.
That's correct. And that witness, by the way, was the chief deputy coroner, who is responsible for removing the decedent parts from the refrigerator, because they're locked up. You can't get them. All right, unless you are authorized to, in a way. And so he had to bring this child back out, or the decedent's body, and set it up. So he said, I set it up. I was there. He wasn't there. I went to the front. I saw him just looking at pictures. And yet they bring in this sheriff who said, no, the body was there. So the judge says, well, he said the body was there, therefore Dr. Montez must have been there. He never says Dr. Montez was there, but the judges are assuming that in their statement. It's ridiculous, okay? And here's the other thing. These judges are passing judgment on who's right in the interpretation of the x-ray. The defense brought in a board-certified neuroradiologist from a high-ranking institution who reviewed the film and testified there is no skull fracture here. More importantly, the description that the two pathologists, Choi and Montez, gave with their naked eye makes absolutely no sense. You cannot have what they describe as this through-and-through fracture and not see it on the x-ray. It does not happen. The judge said, well, it's 3 against 1.
Now, this was new. This was not part of the original trial, correct?
That's correct.
And that's important because that's what allows a motion for a new trial to come in, that there's evidence, useful evidence that wasn't known at the time. So if those x-rays in the first instance were not readable, then the defense attorney could not construct the defense
was this brought
properly.
Up in the appeal court?
What was brought up? The new evidence?
Yeah.
Yes, in the appellate court.
Yeah.
Right.
And
Well, it was also brought up in the circuit court under Shanes. Okay? All right?
And
But I think the
still-
decision was that it wasn't really considered new evidence. Is that?
That's correct. They did not consider new evidence
said
because
it's the same old stuff.
They're saying that your bad images were because they're compressed. Down below, if you knew how to manipulate this little icon, you could have got better images. But as I said before, he couldn't manipulate it to get the better images, so he went back to the prosecutorial attorney, Kristen Bishop, and asked for help. Not once, but twice. And twice they told him that's all you can get.
Okay.
I think it's, and I want to introduce a point here too, is that much like your prosecution running for coroner, When we're talking about this, we're getting into some deep areas of technical stuff where you kind of have to follow the story, and it took me a number of times of looking at the whole picture before I understood it. But what we're talking about here, something very fundamental, and that's, does our system of justice work? Is there, in fact, an innocent young lady sitting in prison right now that's doubling the tragedy of this child's death? And it's not a game of gotcha. It's not a game of saying, well, this little legal rule went here and this went there, and it's just too bad if it went off the wrong way. There has to be an appeal to saying what really happened and what really occurred here. And the judiciary is the one that has to step up and apply these doctrines of justice. Essentially she's being denied her due process if she had, didn't have those x-rays, and if there is in fact perjured testimony, or if there's appellate justices substituting their judicial reasoning for medical opinion. I think that's one of the things that's at the core of this case myself, is that I think that the justices have not understood the medical facts, that it's a scientific impossibility for this child to have died of the causes at Melissa's hands.
Is there
So I'm sorry.
That's excellent. I'm glad you said that.
Is there an underlying force that's keep this from happening and keep,
Well, let me venture what I think. Well, first of all, let's make it clear. This is a corrupt county in terms of putting the wrong people in jail. Okay, we've had 6 cases before the current state's attorney. Okay, national news, statements made under the Waller administration by his subordinates that were so bad he fired people because they were obnoxious and obscene. Okay, and so here you've got, I think, they just don't like to admit that they made a mistake. And Matt may comment on this. When you're a state's attorney, you're in a political job, whether you like it or not. It's politics. You've been elected, okay? Therefore, you need as high a conviction rate as possible to move on, okay? Be it in politics or in a private firm, all right? If you come out, I got half of them right, I don't think you're going to be hired by the top firms, okay? All right. The other thing is, and I think, and don't mean to negate any or make any negatives in lawyers, but I think the fact that her father, Paul Calusinski, was an ankle biter, or he was salt in the wound. He was on the TV. He was criticizing. He was protesting, on and on. And I, of course, appeared on 3 episodes of 48 Hours. Okay. And I basically think they got together and said, we don't like the way they've embarrassed us. So let's lock arms and not give in. And the only way this will ever be given justice to the fact is if and when it goes to the federal courts. Once it's out of this state, then we'll get justice. Because I don't have any. I don't think the Supreme Court is going to decide in their favor. I hope I'm wrong, but I think.
Or if they'll even take the case, they don't have to take the case. I want to just echo your point, Dr. Brooks, is that with your question is the role of a public prosecutor is to seek after justice. Okay. Okay, and now prosecutors work with the police. They work with a lot of criminals and a lot of bad crimes. There is a tendency, a very strong tendency, to think that our job, and I'm actually quoting one of the former assistant, I can't think of his name now, it was I think in the Juan Rivera case, which was a famous case of a wrongful conviction here in Lake County, which set the record across the country for the highest punitive settlements against
21 million. 21 million.
Highest in the country in history, where this assistant prosecutor was said that his job was to convict people.
Wow.
Now, if a prosecutor thinks their job is to convict people and not to go after justice, they're going to start to go down a blind alley. There's going to be a mentality that's going to be the hunter and the hunted. And if they count their success with the number of convictions, then that's no different than a gunslinger putting another notch on their belt. That's not going after the truth. It takes a lot of courage to do that. You have to go against the grain. You have to go against the people you work with every day. But in order to keep that position that we hold, that holds the public trust, because these are the discretion to prosecute is almost without reserve. There is no check on that. It's what the public's faith in the prosecutor to do that. So it is to pursue the truth, and it can be very difficult, not just because somebody thinks that they're a gunslinger. Also, there's things like confirmation bias, where if you've already got your mind made up, any new information that comes in you're going to pick and choose what fits what you've already determined. And so on, that's a conversation that,
So we're dealing with the human element there.
Yeah, I think there is a human element. We have to remember that prosecutor's office is a neutral office, and it's not an extension of the police or police power.
And the prosecutor has the final word, right?
No, I think the jury has the final word.
Well, they have the final word on what they're going to bring to what they're going to charge.
Yeah.
Right.
Yes.
Correct.
Yeah.
The jury or the judge, depending on
So
whether you have
in
a
this
jury
case,
trial.
in Melissa Calusinski's case, we're talking about decisions made by judges, appellate judges, reviewing courts, or in the first instance, the jury. So we're not talking about the prosecutor who's been assigned to this job to prosecute somebody that's been charged. But with that said, I believe that the state's attorney could, on their own motion, reopen this case if they felt it was unjust.
He's still in a position to do that.
Yes, he is. Yes, he is. And he promised that he was going to examine all these cases and do that. And he did. Melissa was one or two that he didn't do. And he said he's read the evidence, including the autopsy, and he can interpret medical evidence. I read up on it too when I was a candidate for state's attorney, and I just think that he was wrong about that. But that's why we talk about these things, and that's why Dr. Rudd's been out talking about this case, and it's not the only case. It's one of the larger ones, and one that's gained a lot of attention. And
community forum is just a outlet for information for the public, and there's two sides to every case, and we open it to. I've had state's attorney on several times, talking about this, and if you want to come back on again, he can come on again too.
Oh, he's talked about this case?
Okay.
Okay.
Well, we're not about this particular case. So.
Right. He won't do it.
No.
Because after the appellate court ruling, he refused to comment, which is probably the correct thing to do. Okay, because it's still pending. In other words, it's going to go higher. So he made a right decision. But if he'd like to appear with me to discuss the autopsy, I'd be glad to debate him in the autopsy.
No, that'd be all right to do.
Yeah, that'd be all right to do.
No, I mentioned about information, general information.
Yeah.
Yeah.
That's correct.
For the public's, information, again, I keep reviewing this, the manner of death. You say there are 5 manners of death, right? Not cause of death, but manners of death.
There's hundreds of causes of death.
Okay.
When somebody dies, there's a cause and there's a manner. Okay. The cause is he got shot in the head by a bad guy.
Okay.
That's a homicide. Okay.
Okay.
Now, homicide doesn't mean murder. That's up to the state's attorney to decide.
It
Okay?
means a man
Okay,
who was killed by man.
Right,
This is
somebody
a
kills
homicide.
somebody. Okay.
Even a death penalty execution is a homicide.
Right.
Okay.
Somebody commits, hangs himself. That's suicidal. Okay?
Okay.
Somebody's driving the car too fast, goes off the road, dies. That's an accident.
Okay.
Okay? Then there's natural deaths.
Okay.
That's cardiovascular disease. That's tumors. That's everything every disease you get from just living nice and old. Okay? That's natural. Then there's the rare cases of undetermined. And the vast majority of those rare cases were what known as crib deaths. Okay? Sudden infant death. Even that's disappearing because we now know why children die when they're put to bed. It's because they're put down, face down,
Okay.
or they're put with blanket, and they haven't developed their neck muscles so that they can move themselves when their airway is cut off. So they have to develop their neck muscles to be able to go from face down to flip themselves over. So we now know what the cause of these deaths are. It's asphyxiation due to the fact the child can't turn himself over.
So that's what used to be called sudden infant death?
Correct. And so now they're educating the parents, watch your kids, when you put them on their stomach to see if their if they can turn themselves over, you can safely put them to bed face down. However,
That's a good thing I don't think that's generally known. I'm glad you're speaking about it.
That's what the literature is showing. So you still should put your child on their back when they go to bed, even if they can't turn themselves over. Okay, but it's nice to know when you see your child, if they're in bed and they fall asleep face down, and they can turn themselves over. They wake up and they turn themselves over. That means they have developed musculature so that if they're short of breath due to the position they're in, they can do it by themselves. And that develops like maybe 9 months or something like that. Okay, each child's different.
Now, what will you be doing with yourself? You have any leisure time activities, or are you still going to be?
It's called honeydew. You know what honeydew is?
You're on a melon diet?
I should be. It's, my wife's saying, honey, do this, honey, do that. Okay.
And is there anything else, dear?
Well, I still keep an interest in keeping this county honest, and I think in the next few weeks I think you're going to be hearing in the news some unusual activity in the county that I've been working on.
Okay. Okay.
Oh, that sounds tantalizing.
It certainly does. I've even called in some help.
And Attorney Stanton, what do you do for leisure time activities?
These days, I really don't have much. I tried to get to the Renaissance Fair. I used to perform there for leisure activity, but I haven't had time. And I guess what I do for leisure activities is my teaching, and I also serve on the board at the College of Lake County.
Okay.
And,
Okay, so that's interesting too. So you're lawyer trained and.
He's also a professor. He does a lot of
yeah,
teaching.
I've always been interested in education as well as, because that's one of the key ways to elevate oneself. And the more education that we have, the more we're able to act in this democracy that we have as agents of change. And, if we deserve good government, we have to work for it. We have to stay on top of it. It's not just casting a vote and walking away and saying, well, that's their problem now. Voting's just the smallest of the things that we can do.
I think what Matt said is very important. Unfortunately, the average American struggles to make a living, struggles to educate their kids, struggle. They're very tired. They get some leisure time. They don't want to pay attention to politics, but you have to pay attention to politics. You have to, especially locally. You might not have to get involved in national, but you need to stay alert locally. Okay, and if you don't like what you see, you become active and you vote. I'll give you 2 examples. I know we're running out of time. In St. Mary's Parish, St. Pat's Parish, they blocked a car wash because the community rose up, went to city council in Lake Forest and blocked it. Yet the man who wanted it was massively wealthy and powerful in Lake Forest, and they stopped him. Second thing is the siding that runs through Deerfield and Lake Forest and elsewhere. There was a train siding. They blocked that.
Okay, you mentioned about time. We have come to, so I want to thank both of you for taking time from your busy schedules to be with us on Community Forum. Ladies and gentlemen, we've been talking with Dr. Thomas R. Rudd, former Lake County coroner, a stellar forensic pathologist, and also attorney Matthew Stanton, who's an attorney at law. And there are many cases here that have demanded Lake County attention. Melissa Calusinski is one that's current, and we had the Hannah case that was resolved in North Chicago, and we have others, policeman that was
Fox Lake,
Lieutenant
Lake, Glinowitz,
and so forth. So there are many, and Community Forum bring this information to you. So thanks a lot. This has been Community Forum. My name is Dr. Waddell Brooks Sr., your host.